We're going to get into our social media check-in right now. Ernie Gustavo Rodriguez left an encyclopedic question, but we're going to answer it because he's a VIP member of the Brad Squad. Hi, Brad. My dad had a labor certification submitted before April 30th, 2001. We came to the country in 1999 and have been here since. For that initial process, we had a notarial work our case, and needless to say, it didn't go very far. He passed away a couple of years after 2001. In 2009, we started a process with a new sponsor. We had a Department of Labor approval notice for unskilled workers, and I-140 was filed. The I-140 was denied in 2011 due to the sponsor not being able to sustain the wage. I'm not sure why the immigration attorney did not check the taxes or if the sponsor was a good sponsor before starting the process. It's now been 10 years. It seems like my dad has found a better sponsor. Does he have to start the process from scratch with the Department of Labor? Since then, he and my mom have divorced. I know all derivative beneficiaries can apply through 245I. Myself and my siblings are still single. Can we be put on the application? Does my mother have her own process, and does that entail her going through the Department of Labor process as well and finding her own sponsor? And my siblings as well. I know it's a loaded question. Thank you for answering. Well, Ernie, you are 245I because any labor application that's filed and approved makes you 245I. Anyone who's derivative of that is 245I2, provided the application is filed before April 30th, 2001, and you were physically present December 21st, 2000. So you, your mom, who now divorced your dad, and all your siblings are all 245I. Your dad has to start over from scratch because all his previous labor applications were denied. When he starts all over from scratch, he's divorced from mom, so mom's not on that case. And you and your siblings, I presume, are over 21. So you are not on that case. So if your dad gets sponsored in a job, the only one who will get a green card through that job sponsorship under 245I is your dad. Can you do your own labor application and then adjust your status under 245I? Yes. Can your siblings? Yes. Can your mom? Yes, because you are all 245I. But you can no longer bootstrap yourself as derivatives on your dad's case because mom and dad are divorced and you are all over 21. So basically everybody needs a new case, but you're all 245I. Lawrence and DB asks a question, also from Brad Squad VIP. I hear some other lawyers say wait 60 days before you marry, and you say 90. What is the clear, correct amount of days, and what is the difference of 60 or 90 days before somebody gets married? Let me be very clear. It's 90 days. If you come on a visitor's visa and you get married in less than 90 days, there is a presumption that you entered the United States to get a green card as a visitor, and you committed a misrepresentation. If you get married between days 60 and 90, there's a rebuttable presumption. What that means is that the immigration officer will say, you came here to get married. You're a liar, misrepresentation. And you will have to argue that, no, that's not true. I came here to visit and something happened and I changed my mind and I decided to get married. You're taking a chance by making that argument. Immigration officer may believe you, may not believe you. You may be lying, you may be telling the truth, who knows? You're now leaving it to the discretion of the immigration officer to determine whether you get a green card or not, whether you're lying or telling the truth. Don't leave it up to the discretion of the immigration officer. Get married after 90 days. Now there's no discretion anymore. The immigration officer, as long as it's a bona fide marriage, has to give you a green card. It can't be any more clear. I believe any lawyer who tells you it's okay to get married in 60 days is not giving you good advice. Bint Uzman. I'm at the National Visa Center stage. My husband is a U.S. citizen. We have a son together who will be migrating with me as well. I have a daughter from a previous marriage who will be accompanying us also. Should we add our son to my I-864 application? Also, can I do an I-864W for my daughter instead of an I-864? Well, Bint? No, the answer is no. Because the I-864 application is just for you, because your children are not included on the application that your husband filed for you. So the only one who's getting their green card is you. If you want your children to accompany you, and your husband's a U.S. citizen, your husband has to file separate I-130 visa petitions for each of them. So by you including your children on I-864, that's not getting them their green cards. When a U.S. citizen husband files for a wife, the U.S. citizen husband has to file separate I-130 visa petitions for each of his children. Thanks for watching. For more Brad Show Live, like and subscribe to our YouTube channel.